Hello everyone. I have created this brief video on topic extension of time in construction contracts. We will discuss in detail about subject topic extension of time, how to request extension of time in most correct way, and relevant facts related to it, and we will discuss what are the course of actions required post extension of time proposal. My name is Shubham Singh. Let's start this video. The content of this video is listed at screen.
This video is divided in 4 sections, which is Introduction to Extension of Time, Essence of Valid Extension of Time Proposal, Contractor's Duty to Mitigate the Losses, and what are the course of action required post extension of time proposal. What is extension of time? An extension of time clause in a contract envisages provision for the amendment of the original date of completion under agreed circumstances of contract term. A contract validity is a matter of agreement between the parties. However, it must be definite. Parties can mutually agree to alter the timeline of contract under the provision of extension of time in contract agreement. I request you to refer Section 53, 54, 55 and Section 63 of Indian Contract Act. I have also attached a very basic illustration. This bar chart is showing a very basic illustration of extension of time. Let's suppose your schedule start with activity A and complete with completion of activity D. This is the original baseline. However, during execution, the contractor has faced delay during the execution of activity B, and due to which the activity D will complete with some delay. This is the impacted baseline. The comparison of impacted baseline and original baseline will give you the extension of time duration. However, this is a very basic example and we will discuss in detail about extension of time in the upcoming slides. Now this question arises, why parties apply for extension of time? Let's suppose the project is not being completed in the scheduled date of completion as stipulated in the contract. We are not going to discuss who is in the fault, but what are the benefit of extension of time for the both parties. For the contractor, the benefit of an extension of time relieve the contractor from the liability of delay damages, usually liquidated damages, and allows reprogramming of the balance works to complete the project. However, some conditions apply and we will discuss these conditions in the upcoming slide. The benefit of extension of time to the employer is that it establishes a new contractual completion date and prevents time for completion of the work becoming at large. You need to understand the basic difference between liquidated damages and penalties. Liquidated damages are the damages which are defined in the contract, and there is always a upper limit defined in the contract for liquidated damages. However, for penalties, there is no upper limit as such defined in the contract. Let's take an example to understand the difference between liquidated damages and penalty. Let's suppose the contractor is unable to complete the project in the stipulated time frame and the delay is attributable to the contractor only. Hence, in this case, the employer can impose liquidated damages on contractor as per the rate defined in the contract. However, in case the contractor is unable to complete any work as per the standards and specifications specified in the contract, in this case, the employer can impose penalty for not following the minimum standards and specification specified in the contract. Some of the contracts are formed considering time is the essence of contract and some are not. When time is not the essence of contract, the employer can impose liquidated damages, but the contract cannot be terminated. However, in case when the time is the essence of contract, then when a party to a contract fails to perform any promise of which time is specified in the contract or so much of it has to not been performed becomes voidable at the option of the other party. Also, while proposing the relief to perform for the balance obligation, the intention to claim compensation or not to be claimed should be clearly mentioned in the proposal while asking for the extension of time. So, let's discuss what are the grounds for which extension of time can be requested. The delays are categorized in 3 sections. First, the delay from the employer side. Second, the delay from the contractor side. And third, the delay for which no party is responsible. The employer's delay can be access related,
variations, change of scope, change in specification, change in standards, necessary clearance and permits, design and drawing approval, delay in approval, delay in cash flow, suspension of works. The contractor's delay can be slow progress of which the contractor is faulty. The delay for which no party is responsible can be change in law, force majeure events, extreme weather conditions, suspension of work by administration, external risk events. Now, the table below is showing the relation between the delay, extension of time provision, and compensation provision. If the delay is due to the employer side, then you can ask for extension of time and compensation also. However, if the delay is from the contractor side, then extension of time can be asked with the liquidated damages. Hence, we are specifying here that no extension of time can be asked and no compensation will be granted to the contractor. However, in the case when the delay is from neither party, which is already mentioned above, in this case, extension of time can be granted, but no compensation can be awarded for these kind of condition. I have listed some basic requirements which everybody should know before preparing an extension of time proposal. You should know about the baseline, critical path, floats, missing logics, leads, positive lags, relationships, constraints, total float, negative float, invalid dates, resources, missed tasks, critical path. You should also know the interface of Primavera or MSP, which you are going to use to perform the delay analysis. You should also know the construction sequence and working methodology of the subject project. Understanding of the contract term on contractual obligation is also very necessary. Now we're going to start the most important part of this video, which is what are the very basic requirement of valid EOT proposal. Extension of time is a very basic requirement and the foundation for the future claim and dispute resolution. Most of the dispute arises after the EOT proposal. So, we're gonna discuss what are the very basic requirements which you should include in your extension of time proposal to resolve most of the dispute in the early stage and of course try to mitigate most of the dispute without arising. Let's start this. The extension of time proposal shall be supported with proper records and backup. Burden of proof is always on the head of party who is requesting for the relief. Hence, the contractor shall generate contemporaneous record during the execution phase. Contractor shall record all the delay event by mean of correspondences. Correct methodology shall also be adopted during performing the delay analysis, which we will discuss in the upcoming slides. The contractor shall also perform concurrency analysis, which will help during the determination phase by the engineer and granting extension of time. The contractor shall also do the critical delay analysis considering the concurrency and the delay analysis performed by the contractor. The contractor shall also specify whether he is going to claim compensation for the delays which are attributable to the employer. Now, the records which the contractor can generate are contemporaneous record by mean of correspondences, monthly progress report, video records, test, utilization of manpower records, and machinery records. The contractor shall also record the direct costs incurred by the contractor during the execution work, which shall be labor, manpower, machinery, equipments, and also shall record the indirect costs, which are the overheads, rent, and time related cost. The contractor shall record all the delay events faced by the contractor during the execution of works. It may be access related issues, hindrances, and approvals from the engineer by mean of correspondences, minutes of meeting, etc. The contractor shall also validate its original work program by 14 DCMA points compliance. It helps to validate and act as an additional proof check to validate that the baseline prepared by the contractor is correct. The methodology for performing delay analysis can be referred from Society of Construction Law, United Kingdom Protocol 2017 and the Associations for the Advancement of Cost Engineering
International Recommended Practice number 29R-03. In this video, we are referring Society of Construction Law UK Protocol 2017. The type of analysis can be adopted as cause and effect analysis, or the second one, which is effect and cause analysis. Cause and effect analysis method starts with identification and description of an event and thereafter seeking to establish its impact. The reverse of which is effect and cause analysis. The determination of critical path is most important. There are three ways to determine the critical path. First one is purely prospective critical path assessment. Second was is contemporaneous critical path assessment, and the third one is retrospective critical path assessment. Determination of delay event impact can be analyzed by performing prospective delay analysis and retrospective delay analysis method. In this video, I am just giving an overview of delay analysis. I'll create a separate video on delay analysis and prolongation claim. The delay analysis methods mentioned in SCL UK protocol is tabulated on the screen. Impacted as planned method of delay analysis is cause and effect analysis, and the critical path is determined prospectively, and the delay impact is determined prospectively as well. Time impact method of delay analysis is cause and effect analysis, and the critical path is determined contemporaneously, and the delay impact is determined prospectively. As planned versus as built window analysis is effect and cause analysis, and the critical path is determined contemporaneously, and the delay impact is determined prospectively. Collapse as built method of delay analysis is cause and effect analysis, and the critical path is determined retrospectively. The impact of delay analysis is determined retrospectively. Concurrency analysis is very important and it should be performed while requesting for an extension of time. Concurrent delays is the occurrence of two or more delay events at the same time. One an employer's fault and the other a contractor fault, the effect of which are felt at the same time. Two concurrent delay events will be a rare occurrence. In the contrast, a more common usage of term concurrent delay concerns with the situation where two or more delay events arises at a different time, but the effect of them are felt at the same time. It can be said that both the employer's and contractor's delay event shall impact the critical path at the same time to be the concurrent delay events. It is often incorrectly thought that an entitlement to an extension of time automatically carries with it an entitlement to compensation for prolongation cost during the period of extension of time. But it is not. The grant of extension of time for certain period doesn't mean that the contractor can apply compensation for the same period. There, concurrency and delay analysis plays an important role. The employer will always try to prove concurrency and thus extension of time can be granted but compensation goes out of the picture. The table below will brief the effect of concurrency on extension of time and prolongation cost claim. If the delay event A is caused by the employer and the delay event B is caused by the contractor, then it is an excusable and non-compensable delay, and in this case extension of time can be granted but compensation cannot be awarded. If both the delay event are caused by the employer, then it is an excusable and compensable delay. In this case, extension of time shall be granted and compensation shall be awarded. Please refer the table. It will help you to understand the effect of concurrency on extension of time and compensation for extended stay. Concurrency itself is a very disputed topic and may take days of discussion. It is the best tool available to the employer to safeguard from the excusable compensable delay event. Hence, performing concurrency analysis while requesting for extension of time is very important.
During the execution phase, experts like engineers, planners, and schedulers are involved, and thus extension of time granted by them accordingly. But when any dispute arises, and even after submission of your prolongation claims, judges lawyers, arbitrators involved, and making them understand about the excusable delay, compensable delay, non-excusable, non-compensable delay, concurrency is very difficult. So your original extension of time proposals should reflect everything very clearly, very precisely to make them understand what are the excusable delays of that EOT proposal, what are the compensable delay of that EOT proposal, and how much compensation the contractor is going to claim for the delay events which are attributable to the employer. I have prepared this format to reflect the final result of your critical delay analysis and concurrency analysis combined, and it will help everybody to understand very easily the final outcome, that is total extension of time and the total delay event for which compensation can be granted. It also clearly reflects the non-excusable non-compensable delay event, the excusable compensable delay event, the excusable non-compensable delay event along with the concurrent delay events. Thus, by using these kind of formats, you can easily reflect the final outcome of your critical delay analysis, and it will help in the future in resolving the disputes and increasing the chance of granting extension of time by the employer. While requesting extension of time, the contractor shall also submit its intention to claim compensation for extended stay or the other losses incurred by him. Ownership of float shall also be considered while performing delay analysis. We will deal this topic in separate video while explaining delay analysis. As of now, you should understand that the float are owned by the project, means the delay on non-critical path shall not be considered unless and until it will create a new critical path. These are the minimum requirements for a valid extension of time request. The sequence of your extension of time request document can be: first, a cover letter including delay analysis report write-up and concurrency details. You should include a format which I have showed you in your extension of time proposal, followed by delay analysis performed on MSP or Primavera software, along with all the supporting documents justifying the delay events. If you refer the above explained sequence, the chances of granting extension of time increases, and it helps you to sustain for the future claims also. You should note that it is the duty of both the contractor and the employer to mitigate the losses. Thus, the contractor should do its best efforts to mitigate the losses. The contractor can request acceleration measures also. However, additional cost for the acceleration shall be claimed by the contractor for the employer's delay event. Where acceleration is instructed or the agreed, the contractor is not entitled to claim prolongation cost for the period of employer's delay event avoided by the acceleration measure. In this case, the contractor can claim acceleration cost only, not the prolongation cost. Now, we will discuss the course of action needed after EOT proposal. In case of no determination or reply from the engineer or the employer, the contractor should notify in written and try to make it obvious that the contractor is supporting for early determination and provided all the relevant documents to the engineer and employer. In case of impunged determination, the contractor must submit its disagreement as soon as possible and clarify the erroneous considerations. Financial implication due to extended stay and for the compensable delay events shall be submitted as per the timeline mentioned in the contract. We are not going to discuss in detail about the delay analysis and prolongation claim preparation. I'll create a separate video on topic delay analysis and prolongation claim preparation. Based on my knowledge and experience, I have created this video. I might have missed some important aspects which must have included in this video, but I may have not. If you have any queries on the subject topic, please ping me. This is Shubham Singh. Thank you for watching this video.